Hello. In this week's Torah portion, Shoftim, we read about the supreme importance of justice in Judaism. Quote, "You shall not judge unfairly. You shall show no partiality. You shall not take bribes, for bribes blind the eyes of the discerning and upset the plea of the just. Justice, justice shall you pursue, that you may live." The Mishnah says, על שלושה דברים העולם עומד, על הדין ועל האמת ועל השלום, which means the world rests on three things, on justice, on truth, and on peace, unquote. Justice is listed first. It is the most important of the three. So justice is number one with us. It is so vital in Judaism that the full quote says, tzedek tzedek tirdof le'ma'an tihyeh. Justice, justice shall you pursue, that you may live. Indeed, we simply can't live without justice. That second part is often omitted from the quote. The Torah begins with Bereshit bara Elokim, in the beginning, God. And the name for God that is used there, Elokim, traditionally reflects God's attribute of justice. A cardinal principle in Jewish law is that you may not incriminate yourself. In that, it goes well beyond the Fifth Amendment of the American Constitution. The latter says that you have the right to remain silent to avoid possibly incriminating yourself. But you don't have to avail yourself of that right. Jewish law says you must. You are not allowed to testify against yourself or even for yourself, or plead guilty or sign a confession. The judges just listen to the charges from the plaintiffs, examine the evidence, interrogate the witnesses, discuss the matter among themselves, and then reach a verdict by majority vote. No lawyers, no jurors. This principle is implied in the Torah. The Torah states, quote, "Parents shall not be put to death for children, nor children be put to death for parents. A person shall be put to death only for his own crime," unquote. The Talmud argues, why did the Torah not just say a person shall be put to death only for his own crime? The reference to parents and children seems unnecessary. This is to teach us that the verse really means parents shall not be put to death based on the testimony of their children, nor children be put to death based on the testimony of their parents. And if so, all the more reason why you should not be punished based on your own testimony. The Radbaz from 16th century Egypt added that another reason is that your life is not your property, but God's. This is also the basis for the ban on suicide. Why are we not allowed to incriminate ourselves? Maimonides from 11th century Egypt argues that the defendant may become depressed, even suicidal, and confess just to get it over with. Yosef ibn Bigash from 12th century Spain states that a confession could influence the judges to the point that they may not take seriously evidence of innocence. There are exceptions. Judges may require self-incrimination in three cases: major emergencies, major threats, and widespread disregard of the law. Who else may not testify against you? First, close relatives, such as father, uncles, brothers, sons, nephews, stepfather, father-in-law, brothers-in-law, sons-in-law, and first cousins. Second, the husbands of a female relative may not testify. Note that in general, women don't have to testify because the rabbis don't want to take their time away from their duties at home, which they deem more important. However, women may testify if there are no male witnesses. Women have been able to testify in Israel since 1951. Third, the wicked may not testify because the Torah says, "You shall not join hands with the wicked to act as a malicious witness." The wicked in question include criminals, perjurers, informers, thieves, usurers, gamblers, and those who reject social conventions, such as by working naked. The reason they're exempted from witnessing is that they are deemed more likely to lie. At least two witnesses are required. One witness alone cannot lead to a conviction. The Torah states, one witness shall not rise up against a man for any iniquity. By the mouth of at least two witnesses shall the matter be established. Interestingly, there is no punishment for failure to testify on behalf of the defendant, except from God's. The Talmud states, quote, Rabbi Yoshua said, knowing evidence in favor of another and not testifying on his behalf is an act for which the offender is exempt from the judgments of man, but liable to the judgments of heaven. Now, our center topic. A widespread feature in Western-style justice is plea bargaining. Examples are the following offers from the prosecutors. Plead guilty and you'll get a lesser punishment. If not, we'll throw the book at you. Plead guilty to a lesser crime. If not, we'll throw the book at you. Give us information about your bosses and testify against them, and we will give you immunity. We won't prosecute you at all. An example. The police find large quantity of drugs near a woman. Purse, car, house, etc. She's arrested for possession with intent to distribute. Her lawyer tells her she will probably be found guilty if tried, be put in jail, and her children sent to a foster home. But if she pleads guilty to possession only, she will receive only a short suspended jail sentence and probation. She knows she's innocent and was probably framed by her ex-husband, but she accepts anyway. What are the advantages of plea bargaining? From the state's point of view, it lightens crowded dockets because it may lead to skipping trial altogether or lead to a cheaper, faster, shorter trial. Also, a lesser crime is usually easier to prove. From the defense lawyer's point of view, it makes her job much easier, a welcome point if she is paid little as a public defender. From the prosecutor's point of view, it improves his convictions records. From society's point of view, granting immunity in exchange for information and testimony against crime leaders benefits the community as a whole. From the guilty defendant's point of view, it reduces his likely punishments. From the innocent defendant's point of view, it reduces the risk of harsh punishments. But is this justice? What is the situation in the US? Many have argued that plea bargaining is unconstitutional because it removes the right to a trial by jury. Justice Hugo Black noted, quote, the defendant has an absolute unqualified right to compel the state to investigate its own case, find its own witnesses, prove its own facts, and convince the jury through its own resources. Throughout the process, the defendant has a fundamental right to remain silent, in effect challenging the state at every point to prove it, unquote. Nevertheless, the US Supreme Court ruled in 1970 that plea bargaining was constitutional in the case of Brady versus United States. But it warns that if it results in too many innocents pleading guilty, it might become unconstitutional. What is the record? In 2015, 97% of federal defendants took plea bargains. Only 3% stood trial, and 43.6% of defendants found innocent by the court had pleaded guilty. Is plea bargaining allowed in Jewish law? No. Here's why. You can't incriminate yourself, even for a reduced sentence. A witness may not testify if he benefits from his testimony. In particular, a paid witness is invalid. However, the Rashba from 13th century Spain allowed paid expert witnesses. They are not really witnesses to the crime. They only provide needed expertise. One might argue that if offered immunity in exchange for information and testimony, you're not really testifying in court against yourself. Would that make the deal more Jewishly acceptable, even though unfair to others who don't have such information to sell? One might say so. One might say no, because the Torah says specifically that justice must be evenly applied. Quote, you shall have only one standard of law for you, for your countrymen and for the stranger, unquote. Still, one could argue that if lives can be saved based on the information and testimony, pikuach nefesh, then plea bargaining is allowed. Because a temptation to plead guilty to a lesser charge, even if innocent, is great. This point is corroborated by studies and the records. Witness this recent study. In 2013, 2 American professors ran an experiment with students to see whether innocent parties would confess under plea bargaining. The subjects were told the objective was to measure their ability to solve logic problems. Each was paid and paired with a confederate, with strict instructions not to help each other. Half the confederates asked their partner for help and received it. The other half did not. Afterwards, all participants were accused of cheating because of alleged low probability similarities in their answers, and offered a plea bargain. Admit guilt and give up your payments. Otherwise, we'll tell your faculty advisor, who will probably drag you before an ethics board. Of the real cheaters, 89.2% confessed, but also 56.4% of the innocents confessed. And because a plea bargain can be used to be more lenient toward the defendant for whom one has sympathy. It has been noted that if all defendants refused plea bargains, they would all be better off. Only a few would go to trial. This is a variation of prisoner's dilemma in game theory, which shows that people generally don't cooperate even when it's in their best interest to do so. In conclusion, plea bargaining is not allowed in Jewish justice, although an exception can be made in the rare cases where it can be argued that it saves lives. Shabbat Shalom.